All righty, I think it is. We just had a few more join, so let's go ahead and get started. My name is Robert Carroll. I am the Chief of Staff at the Utah Aerospace and Defense Association. If you have any technical problems throughout this, definitely put that in the chat. I'll keep an eye on that, and we'll make sure this is a smooth presentation. We're very fortunate to have Ammon Hansen, Theo Smith, and Joseph Brubaker, if I'm saying that right. Good, I got the nod. From Kirton, McConkie. So I'd love to take a minute to introduce them. Before I do that, I want to tell you a little bit about UATA. Many of you on the call are members, and so we're so glad that you're here. You're here to learn about ITAR and EAR licenses and how to avoid some of the pitfalls there, how to work around some of those, not work around, but work within that regulatory framework, and make sure that you are not getting hit with any unnecessary fines. So UATA is the body that represents Utah's aerospace and defense and security industries. We were started by Governor Cox last year. We were let me take off my screen share there. We have support from the legislature and many wonderful companies here in Utah. We're really excited to have the defense primes as members, as well as a number of amazing smaller companies that are building really cool products for industries that are critical to the national interest. If you want to get more involved with UATA in the future, definitely reach out to me. I'll put my email here in the chat. A little bit of background on me. I'm a BYU grad. Spent much of my life here in Utah, as well as much of my career in Silicon Valley at Google, and studying government for graduate school at the Harvard Kennedy School, and a deep interest in hard tech and deep tech and defense tech, and so have worked on industries that are critical to the national interest, like nuclear energy and more recently advanced air mobility. I'm happy to chat with anyone about those industries, and we have committees within UATA that are focused on those topics. So moving over to the Kirton folks, Kirton McConkie is Utah's premier full-service law firm with 5 locations and more than 160 award-winning attorneys who successfully represent IP, business, international trade, litigation, aerospace and defense, international arbitration, and more. The firm's attorneys have represented clients in more than 150 countries and all 50 states. And so introducing our panelists today, and then I'll jump off and let them do all the talking. They have some awesome slides to share and some really good content. Mr. Joseph Brubaker is a shareholder at the law firm in Salt Lake City. He advises clients in the aerospace and defense industry on international contracts and complying with export controls, trade restrictions, and economic sanctions. In addition to working on projects for the Lockheed Martin F-35 Lightning II, super cool, he has assisted clients with projects involving satellites, drones, rockets, missiles, propulsion systems, tanks, armored vehicles, lasers, guns, encryption, carbon composites, chemical processing equipment, and advanced electronics, computers, and materials. I know many of you on the call are working in those industries, so definitely relevant here. Moving on to Ammon Hansen, a shareholder at the law firm in Boise, Idaho. Mr. Hansen helps guide companies on domestic and international business matters involving international trade, export controls, enforcement matters, anti-corruption, sanctions, disputes, and litigation. Prior to joining the firm, Mr. Hansen worked as a legal director and senior trade counsel at Raytheon. Also a great member of UATA and has a great presence here in Utah, advising Raytheon on global trade and compliance matters, conducting internal investigations, drafting voluntary disclosures, and leading due diligence efforts. And last but not least, Theo Smith advises clients in the aerospace and defense industry on EAR and ITAR export compliance, as well as drafting and negotiating international trade contracts. He also assists companies with mergers and acquisitions and general corporate needs. He serves on our board of governors at UATA, so we're very grateful for that. And I will turn the time over to Mr. Joseph Brubaker. Thank you, gentlemen, for being with us here today, and I'll give you the floor.
Thank you, Robert. It's a pleasure to be here with the Utah Aerospace and Defense Association. Kirton McConkie is on the board and is very grateful for all the work that Robert and his colleagues do to promote the Utah aerospace and defense industry. And among other things, complying with applicable laws and regulations. We're very excited by the growth that's occurring in Utah right now and around the United States. For better and for worse, the aerospace and defense industry is needed more than ever, growing more rapidly, and there are more and more export controls, which we'll be talking about today. Today, we will provide an overview of licensing under export controls. I will provide a brief introduction about the EAR and the ITAR in a minute, but I did note that we have on our call today Special Agent Naomi Morrow. A pleasure to have you. She is the enforcer in Utah out of the Office of Export Enforcement for the Bureau of Industry and Security for the U.S. Department of Commerce. So if there's anything I can emphasize at the outset, we really, really want you to comply with the export controls before you meet her in person. And I mean that with love. With that, let me jump in. Kirton McConkie is a full range of legal services provider. We do everything, including export controls and other import and export issues. We're going to talk about two topics. First, we're going to have Theo Smith talk to us briefly about the export administration regulations. The export administration regulations govern almost every export, and there are a lot of regulations. They're very complex and very comprehensive. So we'll give you an overview of those today. And then secondly, the more stringent but more easily to apply regulations are the international traffic in arms regulations, which Ammon Hansen will speak to us about. These regulations govern those items which have been deemed to be used for military purposes. I say they're easier because over the last decade, especially in the Obama administration, the United States went through export control reform. The goal of that was to make the ITAR easier to apply, easier for companies to know what is a defense item and what is not a defense item. As a consequence, in my opinion, it's made the export administration regulations more difficult to use and apply and much more complex. But the goal of the United States is to preserve as much room for U.S. companies to compete on the global marketplace without being subject to undue export controls. The downside of that is it has made some of the export controls more complex, and you have to be more careful in complying with them. I think that is about all the introduction I'll give now. I may interject with some more stories along the way, but we will go ahead and turn the time over to Theo if I can get the right screen up. Let's see.
Thanks, Joseph.
Here's our information. We will send a copy of the presentation if you'd like it later. But here you go, Theo.
Great. So as Joseph said, I'll be walking through the EAR section of this. So we're going to touch on the scope of the regulations, the licensing process, and then some of the various exceptions and prohibitions. And at the outset, I need to stress this again. Today's information is not exhaustive. There's exceptions to exceptions. So please don't go file something based on only what you see on the slides here today. You want to move on to the next slide, Joseph? Thanks. So first, let's talk about what actually is controlled by EAR, the stuff, right? So commodities, software, technology in general. The second point here, dual use items, is more complicated, as Joseph pointed out. Clients inevitably ask, how do I know if my products are regulated by ITAR or by EAR, especially since EAR controls items that have commercial and military applications. So there's a couple points to keep in mind when this question comes up. So first, the EAR and ITAR have different lists of controlled items. EAR has the Commerce Control List, and then ITAR has the United States Munitions List. So just at the outset, they have two different lists to check. And then the second point to keep in mind is that if something's specifically controlled by ITAR, then it's going to take precedent over EAR, and it will likely be ITAR controlled. And then the third kind of main point for this question would be unpacking the original intent in manufacturing the item. If it was manufactured or modified deliberately for military application, then it's likely going to be ITAR controlled. And then another point to keep in mind with the scope of EAR is that it also relates to activities and behaviors that you might not think of. An example with this would be things that relate to prohibited nuclear proliferation. Any activities aiding such proliferation or published materials related to such nuclear proliferation would be controlled. And we're going to talk about the definition of export later too. So EAR is quite complex. And then as for the items that are statutorily not subject to EAR, that would generally be published materials, public domain materials, scientific or academic output, which is used primarily for curriculum or instructional materials. Most patents, all public patents, and then any non-proprietary information which has been printed and shared. Next
Theo,
slide.
if I can interject
Oh, yeah, go
here.
ahead.
I find that most Americans don't realize just how broad the EAR is. Almost everything is subject to export regulations. And I suppose we don't realize how broad it is because of how easy it is to export most items. Most items are authorized without obtaining a license or looking or doing any further work. But sometimes I say everything's regulated but paper. That may be an overstatement and an understatement. It's most paper is not regulated. If it's paper on how to make nuclear weapons and chemical weapons, then it is regulated. But the breadth is quite amazing. We sometimes have clients try to see if they can make stuff outside of the United States so that the EAR won't apply. But even that is quite a challenge.
Yeah, thank you. And I think later on we'll touch on that briefly as well. Items outside the US are still subject. Oh yeah, here you go. Here's a list of the various types of exports. Joseph said many people don't realize they're exporting. So that's why violations, can happen so easily. And this is why. So the first point here, actual shipment, is what most people think of when they think of the word export. You have a tangible good, you have stuff, and then you ship it to a different country. So that's covered, of course. Electronic transmissions are controlled. Temporary exports won't get you out of the EAR regime. You can't tell the Commerce Department you meant to bring it back in a couple of weeks. So that's why you're exempt. Another important note is you don't need an actual sale. You don't need consideration or a purchase. Just merely transferring the information or the good, whether by gift, donation, or sharing information, would still be an export. And then this last point, deemed export, is pretty interesting. So you can export EAR and ITAR controlled articles just by sharing the information or the goods with a foreign person, even if the foreign person is within the United States. And those of you familiar with ITAR will realize this is familiar. It's very similar, just small nuance differences with the definition. But this point makes kind of internal compliance extra important in terms of personnel and immigration status, because that can lead to unwittingly violating EAR. And then as for re-exports, if you have something manufactured in the United States and then it's exported to a foreign nation, and then some user in that foreign nation exports it to a different foreign nation, that transfer can be controlled by the EAR. So you can't just wash your hands and think you're done as soon as it leaves the United States. And then the second point, origin content. So this is pretty interesting, can get a bit tricky. There are different thresholds of how much of the article is manufactured in the United States, and those various thresholds trigger various controls. So an example would be there are various products when they reach 10% of having US origin content or components, then suddenly certain embargoes apply to the product. And then there's lists of items that are always controlled, which Joseph mentioned as well. As for transfers, this is interesting. It's very similar to the US origin interforeign re-exports. And this is basically when you have a controlled item that's been exported, and then it's re-exported within the same foreign nation. So we call that a transfer, and such transfers are also controlled by EAR.
Yeah, let me jump in on that point. This strikes a lot of foreign companies as shocking when they first learn about it. But the US doesn't just control how items are sent out of the US to another country, but they also control once they are re-exported from that first country to other countries. If you think about it, and this is often referred to as the secondary jurisdiction of the United States. If you think about it conceptually, the rule has to be this way. Otherwise, people could just try to avoid controls by sending items to another country first, which is referred to as diversion, which in particular, since all of the sanctions on Russia has become a popular topic where Russians are trying to buy US items from third countries, and companies in third countries are trying to resell those items in contravention of US law.
Yeah, excellent point. And we're going to talk more about end users and end use as well. There's so many variables here. You can go ahead to the next slide, Joseph. Great. So the specific bureau that you get the license from that you'll be communicating with is the Bureau of Industry and Security within the U.S. Commerce Department. And so we're going to go through some of the steps that it takes to perform an AER export control analysis and then actually obtain a license. Hopefully a lot of this is practical guidelines that'll point you in the right direction. So yeah, 5 steps. We're going to unpack each one. So you can move on to the next slide, and Joseph, we'll get started on the first step. So the first thing you want to do is classify your item by identifying its export control classification number in ECCN. For those of you familiar with HSR filings for antitrust, this is very familiar to getting an NAICS code. It's a specific number that the government applies to, all items. And once you have it, that's how you begin your AER analysis. So you can see here, there's different categories for different items, different groups, various subcategories. And here, why don't you move on to the next slide, Joseph? We'll look at an example of what it looks like when you identify a number. So here's an example, some screenshots of what it looks like when you dig into the EAR. So you can see that this is an entry for 9B515, test, inspection, and production equipment specially designed for spacecraft and related commodities. And then there's different controls. You can see reason for control, NS, RS, AT, and then some complicated country chart, supplemental, cross-reference columns here. And it's quite a complex analysis once you have this, because there's so many different areas and statutes that you need to double and triple check to make sure you've got a comprehensive, accurate read on the ECCN. And people always ask, is the item in this control group? Is it in this control group? And the answer is a lot of these products are controlled with multiple controls, and we're going to unpack that too in the next couple steps as well. So various countries have various controls. It's not as straightforward as Australia can't get this, or Australia can get this. So there's a lot of moving parts that come into play when you begin the analysis here. Joseph, do you want to jump in on this step, or should we move on to what you do after this?
Yes, certainly. My first thought on this is, when it comes to the ITAR, you either need a license or you don't. And most of the time you need a license, and you just know you have to go apply for one. Where here in the EAR, it really depends upon what item you're exporting, where you're exporting it to, and how it's going to be used. And I included this as one of the more simple cases we've used recently, but even as I look at it, I don't find it that simple. It's what is this? Test, inspection, and production equipment specially designed for spacecraft. In this case, it was a test system that basically created a pressure vacuum, and they wanted to stick satellite and solar panel pieces into the vacuum to see how they would perform in the vacuum of space. These items are controlled for national security purposes, for regional stability, and for anti-terrorism. And so once you figure out these controls, as Theo will point out, you then have to go figure out which countries you can export them to, which ones need licenses to export them to, and which ones you'll probably never get a license for. But even if you get past all that business and legal side of it, I do find that you have to work closely with the engineers. For example, the one we were looking at comes in section B right here on the slide. It talks about environmental test chambers capable of pressures below 10 to the -4th torr. I don't know how many of you remember torr from physics, but if you don't, you can probably Google it and figure it out. And then you can figure out what 10 to the -4th torr is. But you're still going to have to go talk to your engineer to figure out what can our equipment actually do and what can it not do. And then as Theo alluded, there's cross references to which sort of items are controlled. This refers to the ITAR's United States munitions list categories, and it also refers to other items on the commerce control list.
Exactly right. Another common question at this stage of the process is, is how can you be sure once you have identified an ECCN what jurisdiction of the federal government you still need to file with? And there's a commodity jurisdiction request that can formalize, and you can obtain an official opinion from the government on whether it's ITAR or EAR controlled. So that's something to keep in mind as well. You want to move on to the next slide, Joseph? Thanks. So like Joseph said, you have to check countries, you have to check end users, you have to check end use. There's so many different moving parts to cross-reference here. So I've attempted to kind of outline some of the main points here. So once you have an ECCN, highly recommend reading every section in the AR that mentions that ECCN. You can't just read one section that's on your country that mentions it or something and then think you're done. There's always going to be some other paragraph that may mention some additional requirement or notation somewhere, or even in the comments and appendices. So you check all the sections on your ECCN. You check all the sections on the involved countries, of course, you know, where it's going, if it's going to get re-exported, where the end country is, and that's different from the end user and the end use. And then there's a country group, which is different from the country chart. So on this slide, it's the country chart. And as you can see, there's a bunch of little X's that show various controls for various categories of export controls for various nations. And so that would be one of the materials you'd always check if you're performing an EAR analysis. And so that's an example of the type of information you cross-reference. So you get your ECCN, you write down all the involved countries, you check the EAR and what it says about all that information, right? And that's different from the end use and the end user, as we keep saying. Can't stress that enough, because the Commerce Department cares about that just as much as the country. And then this last point here, I mentioned UN comments because I performed an EAR analysis for a client that had an item that we thought was good, and then there was an additional comment in the EAR referencing, kind of codifying some UN actions about that country, which was interesting. So, like I said, you never know what's gonna show up. It's such a complex analysis.
So
Joseph,
let me follow up on this on the space system testing the what do they have, the vacuum chamber that they wanted to export. According to this commerce country chart, you could easily export it to Australia or the UK. In this case, they wanted to export to Cairo, Egypt, to the National Authority for Remote Sensing and Space Sciences, which, according to this chart, requires a license.
Yeah, excellent point. Things can change just by changing a millimeter of the product or the country. Yeah, everything rests on a hair. You want to go ahead and move on to the next slide? Thanks. So these are some practical tips for the actual filing. So just to recap, you get the ECCN, you check everything EAR says about it. So then you're ready to put the forms together and tell the Commerce Department exactly what you figured out. And so this first point is very important. You want to define very specifically and accurately all of the technical specifications of the product. You want to document why you've chosen the ECCN, the exact technical parameters of the product, its use and intent. And that includes for technology, you need to talk about exactly which parts of the technology and how it works and how that relates to the end use. As we keep saying, the end use and the end users are very important. So when you file, this should be your opportunity to honestly and accurately, comprehensively tell the Commerce Department exactly what it's going to be used for in the end users. You really don't want to kind of play fast and loose with the specificity of an EAR filing. So that includes providing information that you have on the controls that are in place to mitigate the risk of diversion that Joseph talked about. So you don't want to stop at just telling them what the end user and end use is. You want to go that extra mile and show you have good faith and say, you know, it's our understanding that this compliance protocol is in place, these security precautions are in place. These actions make it less likely that EAR will be violated by end users and end use, right? They love that kind of stuff. And then this last point, very interesting. So the license you obtain to export under EAR authorizes exports and re-exports to and among all the end users that you list on the application, assuming that it's approved in the version that you file it in, right? So if you accidentally leave off an end user in the filing, then even though the Commerce Department doesn't have a problem with anything else in the filing, it'd still be a violation if your product ends up in the hands of a related end user that wasn't specifically listed in the application. So it's important to, kind of triple check the forms to make sure everything you need and want is actually written down and communicated and articulated explicitly when you make the filing.
Yeah, I guess I'm just observations I've had, especially from Utah exporters over the years. Companies that get good at this or export the same product often can repeat the applications. The main application form is only one page. It's not particularly difficult, but I do see some companies, they have engineers fill it out, and the engineers don't provide enough detail for what the legal requirements are. And so sometimes the license applications get kicked back for that reason. Something I try to tell our clients is send a picture. It'll help the reviewer understand what you're talking about. And if you know exactly where it's going to be used, send a picture of the end user and where it's going to be. That will help. It'll make it more fun, at least for the reviewer to review the item.
Yeah, that's a great tip. We can move on to the next slide. Great. So I've combined steps number 4 and 5 here together. So there's a government waiting period. Shouldn't come as a surprise. It's approximately 30 days. I think the current statute requires the appropriate agency to make a decision and get back to the filer within 30 days, but that begins after the appropriate agency has it in front of them. So there are cases where you file it and then the Commerce Department, the Bureau of Industry and Security will kick it over to another agency's desk. I believe they have 9 days to do that. So it's about 39 days max under all scenarios, I believe. In terms of the actual license, once you get it, it's usually 4 years, but just like everything else with the EAR, that varies. So you need to confirm that. You don't want to be flying blind into the future and just have your license expire and continue engaging in these. Some serious repercussions if you do. And then as for ongoing compliance, it's important for companies to have internal protocols in place to avoid violating the EAR or the ITAR. This includes training the appropriate personnel and rigorously, accurately, identifying those ECCNs for all the products that you're going to be exporting. So you know exactly what needs to happen with all the products that you're dealing with, right? And then this last point, SNAP-R, that's just what the portal is called for filing for EAR. And it's important to remember, just with other government filing portals, that they can respond to you and ask questions, and you want to timely respond to those questions, obviously, because you're not guaranteed just a smooth sailing, silent 30-day waiting period.
Yeah, let me add a few thoughts on this. I've received licenses as fast as 10 days. The Bureau of Industry and Security is interested in issuing licenses where they're appropriate as quickly as possible. Usually it is about 30 days. I had one case a couple of years ago where the company had filed the license application on their own and hadn't heard anything for a year. In fact, they filed, if I recall correctly, 13 different license applications and heard nothing. And what ultimately happened was the Bureau of Industry and Security could not understand what they were trying to export. The company had given the Bureau of Industry and Security, with the one-page application, about 100 pages of technical documentation for each license application. And despite all the information, the Bureau of Industry and Security had no choice but to return the application and say, what exactly is your product? So it does help to explain it to them to help them process it rather than just burying them with information. And so if you haven't heard within 30 days, it's worth a call. The reviewers at the Bureau of Industry and Security are not experts in your product, but they are rather intelligent people. Most of them have PhDs, often in nuclear or weapons or other topics. So they're generally familiar with the field, but it helps a lot to explain it to them what you're trying to export so they can make a timely review of your application.
Thanks, Joseph. Yeah, there is a fine line between specificity and clearly articulating what you want. Let's move on to the next slide. So as we mentioned, there are some more clear-cut prohibitions on exports. These are just some examples. There's embargo destinations and nations, embargoed end users. North Korea, easy example. Most exports are going to be de facto prohibited. Again, there's exceptions to the prohibitions, exceptions to exceptions, but it's important to keep in mind there are various lists and various embargoes that will interact with the EAR analysis. So you might get halfway through checking everything and think that you're good to go, and then you run up against one of these other prohibitions or other lists or sections that say actually you can't do that. So this is more of a straightforward category. Most of it's codified list, actual lists spelling out what's prohibited, but very important to keep in mind. Anything on that from you, Joseph? We can move on.
But maybe just the bottom bullet with the different lists. The current challenge, well, I guess for the last few years we've seen is the export administration regulations, like all regulations, are changing. And one category is military end users. In China, most notably, but also in other countries, some companies are sufficiently under the control of the government that it's not clear that they're a private company, even if they hold themselves out as a private company. So you have to be careful that you're not dealing with somebody on one of these lists or who fits the qualifications of one of these lists as being a company that they may be telling you that they're using their product for civil applications, but they may actually be using them for military applications.
Yeah, it's a great point. Just recently in the news, Russia's mercenary groups have been in the news a bunch in the last week. And one example that came to mind is, they have a bunch of bases and they have a big presence in Africa. So perhaps an export to that African nation would be okay, except for the fact that it's going to that specific group. So yeah, it's more to keep everything in mind. We can move on to the next one. Next is exceptions. So again, this slide isn't exhaustive. There are more exceptions and exemptions to EAR than the ones listed here, but these are some of the more straightforward ones and good for giving an example of the types of exceptions. So there's the first one, temporary export of tools of the trade. These are primarily tools used for servicing or repairing certain commodities. An important note and condition for this exception is that the controlled items will remain under the effective control of the exporter at all times. It's important to note there are conditions even to the exceptions. And then of course temporary, it's going to be returned as soon as practical. The second one, gifts. This is interesting, humanitarian donations. So very common transfer of goods and even money, but money is controlled by the Treasury Department. But gifts and humanitarian donations have general exceptions to EAR controls. But you have to note, you have to make sure that the items are still not controlled for other reasons, such as nuclear activities. Another one, personal baggage for personal use. That's ordinary for items that are ordinarily used in the person's employment, and again a temporary period. So the Commerce Department has a heart. There are exceptions to these controls, but they're within certain conditions. On the right here, the public domain exception we alluded to earlier. This is just an interesting one because at the very beginning we talked about items that are statutorily not subject to EAR, public domain materials. And this is just an example of an exception to an exception. Public domain materials may still be controlled if they contain proprietary, classified, or controlled technical data. So you still got to be careful. You can never just think you're one and done with these statutes. That's all I had for the AR section, Joseph. Did you want to add anything?
No, we've covered a lot of material very quickly and only at a very high level. If any of you are in the software industry right now, that seems to be the theme of this year, whether it's AI related stuff or encryption related stuff. We have one client who sells a product that uses 8 other companies' encryption coding. And so these are the things you need to look at. So when work closely with your engineers, figure out what your product is, and avoid if you don't do your homework up front, you'll have to do your homework on the back end with our special agent, Naomi Morrow. So we recommend that you make sure you comply with the export administration regulations.
Yeah, it's interesting you mentioned encryption. I was just reading this morning about one of the encryption exceptions that are being used a bunch since CFR 740.17, encryption commodity software technology. It's pretty interesting. So I believe this is our last slide for EAR, so we'll turn the time over to Ammon Hansen to discuss the ITAR analog to all of this. Thanks.
Thanks, Theo. Yes, I'm Ammon Hansen. I'm based out of the Boise office of Kirton McConkie. And I'm here to talk today about the ITAR. So Joseph, if you'll advance us to the next slide. I want to start off up front going through some kind of key definitions which are key in the ITAR. So it's first of all important to understand the differences between licenses and agreements, and we'll talk a little bit about some of the overlap between them. But basically, you're going to get licenses and use them for permanent and temporary exports and for temporary imports of defense articles, defense services, and technical data. So that's the primary use of the licenses. And we're talking here this time about licenses to the State Department, to DDTC. Now, agreements, on the other hand, are used for U.S. persons to provide defense services to foreign persons, to authorize manufacturing, to authorize distribution points for warehouses. So that's what agreements are for. We're going to focus in this presentation more on the licensing side, but it's important to understand that there are different types of tools that are used when working with the State Department. And we're also going to see in just a second the overlap. So Joseph, if you'll move to the next slide. Here are some definitions, paraphrased, of defense articles, defense services, and technical data. So when we're talking about defense articles, really the key here is the USML, and that's laid out in the ITAR 121. And there's different categories. I've got a slide in a second that will show some of the different categories. But much like Theo was talking about with the CCL, with the ITAR, you're looking to see if the item that you have falls under the USML. Additionally, technical data that is related to the defense articles can also be a defense article in and of itself. Unfinished products that you have that have reached a stage where they're identifiable as a defense article falls into that. So we have several items. Defense services involve the furnishing or the training to foreign persons of all of this kind of technical information, design, development, engineering, etc. And then when we get to technical data, we're talking about the information required. So it's all the drawings and the blueprints and the plans and information covered on an invention secrecy order. All of those different items can be technical data. So if you start to examine these definitions, you might start to scratch your head a little bit about, wait a minute, do I need a license or do I need an agreement for what I'm about to send? So the example is, if you look into the definition of defense services, the second bullet there describes the furnishing of technical data to a foreign person. And so if you'll jump to the next slide, Joseph.
Real quick, can I ask you a question now? And I'm curious, do you see, which of these three categories do you see the most of?
It really depends. A lot of times when these come in, initially you're talking about, you have a defense article, you have a piece of equipment, you have something that you need to send abroad, you've got to send to a foreign party. But inevitably, there's going to be technical information, there's tech data, and you have to look along the whole phase of the relationship you have with the foreign party. Up front, you may have some technical data before you even have a contract with a foreign party that you need to send over. So in the early stages, you're probably seeing potential tech data that you're using for marketing and for other things that you need to have a license for to be able to share with a party. Once you end up in a contractual relationship with a party and you have approval from state, you're going to get to the point where you're sending over defense articles and the actual equipment itself. Oftentimes, though, that additional tech data needs to go with that. So I'd probably say I see tech data the most, just because of the nature of telling people up front what it's about, and then telling people after the fact what's needed for the defense article. So, yeah, I would probably say the technical data.
Right. I was going to say, I see the same thing. And one place where I see it a lot is when people create customized tools to build defense articles. And those defense tools reveal data on what the defense articles are going to be like when they're produced.
That's right. That's right. So to kind of jump to the question I asked, when do you need a license and when do you need an MLA? The potential here is that either one you choose may be the wrong answer, and the State Department may come back to you and tell you you chose wrong. It's just kind of a high level. Typically in the early phases, when, as I talked about, you're marketing, you're kind of pre-contract with a party in a foreign country, and you need to send them a one-off document. Typically in those scenarios, a license would be appropriate. These are sometimes referred to by practitioners as marketing licenses. So in those types of circumstances, that's often what's appropriate. Once you get post-contract and you're dealing with more voluminous documents and post-contract award, technical exchange, those kinds of scenarios, you're probably going to need a TAA or an MLA, depending on the nature of what they're doing, to be able to export that information. And if you get it wrong, then you can take a second stab at it with the State Department. There's some other things that kind of go into this distinction. If you are doing offshore procurement, sometimes you can get away with the DSP-5 with just a license. Or if you're just having one-off documents that are being sent that you may not need a full TAA or otherwise. But I just wanted to highlight that. So,
I got a question for you. Maybe we could talk about TAAs and MLAs just a minute more. I clearly remember my first exposure to them. The ITAR requires that you enter into an agreement with your customer. This agreement is separate from the agreement or purchase order you entered into to get paid. It's completely regulated, and the government has to approve it. And I thought it was weird, but my Australian counterparty thought it was even more weird that they had to enter into some agreement mandated by US regulation, but that was separate from the regulation. What's been your experience at Raytheon with other parties dealing with these agreements?
No, you're spot on. And even before that, I remember the first time years ago when I started working on these, having to kind of rethink my whole approach to agreements, because you're right, you have your purchase order, or you have your contract with a foreign party, and that has nothing to do with your MLA or TAA. That's got to go through approvals, and it's got to go through review and all of that by the government. And so, yeah, you may be dealing with a foreign party that is scratching their head as to what we're even doing here, and why they have to get another agreement when you already have one, or you're already working on one. And that the government has complete oversight, and much of what goes into the MLA or the TAA is dictated by the ITAR, and there's stock language that just goes straight from the ITAR into the MLA or the TAA. It's not like it's something that you have a lot of flexibility to sit down with your foreign partner to try and negotiate. It's dictated as to what needs to be in there. And then, items go into the government for approval, and then the government can add additional provisos and other things that govern and regulate what's going on with your relationship. So it's a great point, Joseph, that we may be, because of ITAR regulations, you may be dealing with something that your foreign counterpart has really no idea why they're doing it, and you may have to educate them on that. So yeah, so if you go to the next slide, this is the USML. I won't spend a lot of time on this slide, but much like Theo said, with the CCL, with the USML, you've got to do an order of review to get through and determine which of all these categories your items fall into. If you go to the next slide, I wanted to talk a little bit about DEX, the Defense Export Control and Compliance System. This can actually help with that. This is the system. If you go to the DDTC website, you can enroll in, and it's a service that, or it's the interface for obtaining any of the following: a commodity jurisdiction, an advisory opinion, your DDTC registration, or to do your licensing. As I've noted there, in the future, we're anticipating that even voluntary disclosures will be submitted through DEX. A commodity jurisdiction, the first item on the list, is a submission. You can request assistance from the State Department to help you identify which USML category is appropriate for your item. So that can be done through the DEX system if you need assistance trying to determine what the USML category is. Advisory opinions would be for things, guidance or direction from the State Department, interpretations of the ITAR, inquiries. I think it's ITAR section 120.22 provides more detail on advisory opinions and what can be sought in those. And then registration, which you need to be registered to be able to apply for a license. The registration can be done through DEX too. So it's a nice one-stop shop. This bolded bullet point at the bottom kind of gives you an idea of the license applications the DDTC analyzes and processes every year, 38,000, and that's straight off of their website. So gives you an idea of the volume.
Yeah, let me ask you a question here. I'm kind of curious for your opinion. So clients basically there's 3 times when they can decide how to classify their product for export. Ideally, they classify it up front when they're making it. Yep. Secondly, they classify it when they apply for a license. Or I guess, let me phrase it. They can classify up front with the government through a commodity jurisdiction or on their own. Or second, they can classify it when they apply for a license. Or third, they're going to have to classify when the government disagrees with them.
And that happens. And sometimes that happens after you've already exported it and the government comes back to you and says, wait a minute, why did you export that? That's the opening of many voluntary disclosures that get submitted to the government is, oops, we sent something that we shouldn't have sent. And we'll talk a little bit here towards the end about voluntary disclosures, because licensing is an area where there's some very clear regulations that need to be followed. And if they're not followed, you find yourself needing to submit a voluntary disclosure. So let's keep moving. The next slide I have are the examples of the 4 primary forms that you'll see: license for permanent export of unclassified defense articles, temporary exports of unclassified, temporary imports of unclassified, and then classified licenses. Now, some of you may be asking, well, what about permanent imports? Permanent imports are not governed by DDTC. Those are governed by ATF, alcohol, tobacco, firearms, and explosives. They deal with all permanent import of unclassified defense articles, and they have their own separate regime. So if you're permanently importing those types of items, it's a completely different regime and government entity that you'll be dealing with to deal with those. Just from a high level, licenses are valid. These licenses are valid for 4 years. Actually, if you'll bounce back to the other slide for just a minute, there are some exceptions to that, and also when your quantity or your value has been exhausted, that's when when the license expires. So there's a lot that kind of goes into these forms, and you can go into DEX and pull down a form and see all the various boxes that have to be filled out. In addition to the boxes that need to be completed, there's some certifications that need to be completed at the end. So for example, on a DSP-5, you have to certify compliance with ITAR Part 130, which in and of itself is a whole separate regime of payments, donations. Let me just find my notes here. typically when you would need to notify the government of under Part 130 is often scenarios where you have a rep or consultant that is assisting you with the solicitation and promotion of the defense article in the foreign country. So if you have a representative or consultant, you're selling an item to Germany or Japan or South Korea, and you've got a representative in the country who's assisting in those sales, you might need to disclose what you're paying the representative or consultant. And so that goes in the Part 130 disclosure. There's a whole separate kind of rules that need to be followed when you have Part 130 implications. But there's a box check on the application for that. You also have to certify on a DSP-5 to compliance with 126.3. Those are things like your president, vice president, others associated with your company are not the subject of an indictment or having been convicted of certain U.S. criminal statutes and some other things like that. So there's a lot of detail that goes into these. And so there's a lot you need to do in advance to kind of prepare and be ready to submit. So if you go now to the next slide, this is just a checklist of things you need to make sure you've done before you complete your application. You've got to be registered. You need an empowered official, a person designated by the company.
Let's stop there, Ammon, real quick.
Yep.
I've noticed that a lot of Utah companies don't realize that even if you're not exporting, you still have to register as a manufacturer of defense articles.
That's right.
Data.
Right. And that actually also brings up another point. There's other things with the State Department that you need to register for. If you are going to engage in brokering, as it's defined in the ITAR, you need to be registered to be a broker. So it's a great point. There may be some other items that you need to register with the State Department before you can engage in if you're manufacturing defense articles. With all of these, you've got to make sure you've complied with the required documentation. The DDTC has some nice checklists on their website of things you'll need both to submit your licenses and then they have the forms themselves, which contain the various boxes that need to be completed. We've talked already about confirming your USML category, confirming your eligibility requirements. Some of that is the 126.13 things we just talked about, completing all the blocks on the license, and then following the general instructions provided by DDTC. And then obviously, if you're submitting classified information, that's got to be done under separate cover. And a classified license, as we just talked about, is a completely different form from the ones that you would be using for non-classified information. On the next page, I've got a sample here of a non-transfer and use certificate, DSP 83. This is a certification that the foreign consignee, the entity that will be receiving the defense article, and the foreign end user will not re-export, resell, or otherwise dispose of of significant military equipment outside the country named as the location of the foreign end use to any other person without authorization. So you need one of these if you're exporting SME, classified articles, classified technical data, or if the State Department tells you need one. And you can see here, if you look closely at the form, obviously this is pretty small on the screen, but it's got to be signed by end user, consignee, and the applicant.
Yeah, let me mention something about that, Ammon, real quick. In the EAR world, for the most part, you don't necessarily need an end user certificate, although it's strongly recommended. But in the ITAR world, you do. They want to know where it's going.
Yep. So in the last few minutes here, I want to touch on two other things. The first is ITAR exemptions. An exemption is basically a provision that authorizes export or re-export or temporary import without a license or other written authorization. And I've listed here a handful of them, but there's over 50 exemptions contained in the ITAR. Temporary import for repair, body armor, the Canadian exemption, the FMS exemption. There's all sorts of different exemptions. You need to read them carefully. They're spelled out in the ITAR. All the requirements for each one of them is spelled out, and you need to make sure you meet every single element of the exemption to be able to use it, as well as keep really good documentation. And that's a key if you're going to use exemptions, is that you have really good record keeping, and you don't, and you can track it. And if there's ever any follow-up, you can provide the documents. So let's move on to the next slide. We'll just do this one quickly. To use an exemption, you've got to be registered with DDTC. That's part of the requirement. Again, you have to meet the 120.16 requirements. It cannot be used to export to a 126.1 country with a couple of very limited exceptions. It cannot be used retroactively. And that goes back to my point again about voluntary disclosures. You can get into trouble using an exemption incorrectly or trying to use an exemption retroactively when you didn't plan ahead to use it in advance. We haven't talked about congressional notification, but sometimes congressional notification is required, and that is going to be dependent on things like the value and whether it's to a NATO or a non-NATO country. There's several things that go into play there, and there's a section in the ITAR that lays out when congressional notification is required. If you do need to have congressional notification, you need to plan significantly in advance because that can take quite a bit of time. All right, Theo, I think we'll go to the next one. This really is just highlighting what I said a minute ago. Read them carefully and keep your records, maintain them for a period of at least 5 years. The other considerations when you're using exemptions, all of these things kind of come into play. Is it permanent? Is it temporary export or import? Classified or unclassified? Significant military equipment or not? Is it U.S. origin or foreign origin? You can go down the list and see these other things. There are some exemptions for licenses in furtherance of agreements. So if you have an existing MLA or a TAA, there are some specific exemptions that you can use to export in furtherance of that MLA or TAA. In just the last couple of minutes, I'd like to talk about violations, and that's my next slide. So just a few that I've highlighted: failure to maintain a copy of your DSP-5 license, export of hardware or technical data to nationalities not authorized by a license or agreement. This can come up a lot. Where I've seen it frequently, you have an engineer in your company who's communicating with an engineer in another company. You don't have any authorizations in place, but they're trying to, get things moving. And so someone says, hey, can you send me over some technical information? The engineer, not thinking about the ITAR requirements, kicks it over in an email, and suddenly your in-house counsel or outside counsel is drafting a voluntary disclosure for you because an engineer didn't realize that they needed a license to send some technical information. Export of hardware in excess of the license value. You've got to keep track of what your license value is and not export hardware that is going to exceed the value that you're authorized to do. Incorrect value information, failure to include purchase order in your license application, improper use of exemptions. These are all some examples. The next slide is one that is a little bit of a trap, and that happens sometimes with the ITAR, is you can be doing everything correctly and then get caught in a scenario where you have committed a violation. So this is one that was recently highlighted on State Department's website, and they highlight that there's been an increase in instances where foreign persons temporarily return defense articles for repair or replacement without U.S. persons' knowledge. So you show up to your mailbox and you have a part that's been imported to you without a temporary import license from your partner in a foreign country. So DDTC has provided some guidelines on what to do if you find yourself in that scenario. And it's basically conduct an investigation, which is what you'd do anyway if you had a potential violation. But they want you to conduct an investigation and determine whether a U.S. person had any responsibility for that violation. If there is no responsibility and it just simply showed up on your doorstep without any involvement from a U.S. person, then the State Department allows you to do a DSP-5 license application with a detailed transmittal letter explaining what happened. And their website provides more details on how to do that, or you could give us a call and we can assist with that. If there was a U.S. person that, engineer or anyone that said, hey, go ahead and send that back to us without getting a proper license, then you do have a voluntary disclosure on your hands. So that's just one instance of where you can wind up with a violation. And sometimes where I think that kind of happens is you receive the part, or your engineer receives the part. Sometimes you don't even realize that you have a violation until it's time for you to send it back to the foreign party, and you want to send it back through a license, and suddenly you realize they never sent it to you with a license, and that's where you have your problem, and that's where this would kind of come into play. So as we've kind of been saying all along, this is a very high level overview. And I'm sure many of you have many other questions. Please don't hesitate to call any of us or shoot us an email. Joseph, I'll turn the time back to you for any concluding remarks.
No, thank you very much. I'm loving how our high level overview still took the whole hour. But we're happy to answer questions and help however we can. Yes, we'd love to help you as your legal counsel, but more importantly, get help wherever you can. We would like you to learn these things before you run into enforcers. So with that, I'll turn it back to Robert, if he's available.
Gentlemen, thank you so much. This was enlightening. I really appreciate it. Thanks for putting your contact information up here on the screen. Sounds like you're open to having anyone reach out to you, so that's great. Theo asked me to put Kirton McConkie's webpage there in the chat, so make sure you reference that in terms of what they're doing in terms of export licensing. I'll also put my email here. Please feel free to reach out. If you lose anyone's contact info at the firm, I can put you in touch there. If you want to talk about anything else related to Utah Aerospace and Defense, definitely happy to chat. So thank you so much. Thank you for your time, gentlemen. Really appreciate it. This has been enlightening. So we look forward to the next time.
Thank you, Robert. It's a pleasure.
Thank you. Bye-bye.
Thanks, Robert.
Thanks, y'all.